Hey, I am Nicole Kaloran. I'm the director of the Vermont Small Business Law Center. We're going to talk about employment. Hiring your first employee. So do you want me to go? Let's go. Let's do it. Okay. Let me switch over here and there we go. I'll do that. So I actually started off with a higher level sort of what issues you guys need to look for in general. You can see the agenda, the things we're going to cover here. The high level view might actually be the best slide in the entire presentation because it's like this is what you need to know. So we'll talk about recruitment, which is a real risk point, managing employees, discrimination claims, and then employee status and employee benefits. So those are the topics. Sorry, I'm trying to get this so that it is set up in the appropriate, trying to set it up so it's over here on the right side so I can look like I'm actually talking to you instead of across the room. Okay. So what are the risk spots? I put this first because this was one of the questions that y'all had asked. Basically, what should I look for? What do I really need to know if I want to hire an employee? And these are the things that I think you probably should know in general. You should know that there's risky spots anytime there's a transition. So this is anytime you're hiring somebody, you're firing someone, promoting someone, doing some sort of disciplinary action, transitioning them to a different position. Anytime there is a movement, bringing in, leaving, moving between positions, those create potential risk spots for discrimination claims. We'll look at what a discrimination claim looks like and how that plays out and how to prevent discrimination claims and also to try to create a better workplace. But those are the hot spots for discrimination claims. Someone saying they've been discriminated against because they were not hired, fired, or promoted on the basis of a protected class or characteristic. The next point that really folks need to know as a small business or an organization is that management can be tricky. And that's on the other side of managing an employee is the potential for an unemployment insurance claim, which if an employee is let go for no cause because somebody's downsizing or they just need to let go of an employee, that can translate into increased costs, unemployment insurance costs for the business. So that's one I just want to highlight. Overtime and benefits are tricky. We'll go through what triggers the need for overtime, how to classify employees to make sure that the ones who are owed overtime are paid overtime. We'll go through the different benefits and what size organization triggers different benefits. There's some that apply to any size organization, and there's some that only apply to like 4 or greater full-time employees. And then we'll talk about, it's not really tricky, but what does it look like to have just a micro business, a small organization, or to have one employee? What does that mean in terms of employee benefits? Overall, the biggest thing I want everybody to take away from this is that if you are going to hire or have an employee, you need to document everything. Applications, job interviews, disciplinary actions, performance reviews, conversations, everything that happens having to do with an employee, signatures on stuff, that all needs to be retained because it prevents against lawsuits basically. And lawyers really want you to not get sued, or they want to sue you if you've done something wrong. I guess that's the other side of the coin. Anyways, those are like the major overview points. I want to pause there. I know that we're going to elaborate on some of those, but any questions for now or spots you want me to fill in for these 5 major topics? Interesting. When is it not a good idea to hire an employee? We'll come to that one. I don't know that that's ever really, I don't know. We'll talk about that one. Okay. So
I think like for me, my question was more about like overall like risk and like cost, of having like workman's comp, for example. Yeah, that's kind of like where I was getting at in terms of that question. Not necessarily like you shouldn't hire an employee, but it's more of like legally.
Yeah.
When does it not make sense to do that? So
I hear you, Jinli, and I think we'll talk about that throughout, I think. And I don't know what the exact cost is. For example, like I don't know what it's going to cost to bring on workers' comp insurance and unemployment insurance. But realistically, anytime you take on an employee, you're dumping money into that person, whether it's benefits or it's training to try to help your business. And so it is something you have to treat very carefully. You need to make sure that you have all the appropriate pieces in place so that no fallout happens and so there's no claims against the employer afterwards. Recruitment. This is a big pain point. This is that you can see these 4 points up at the top here. Risk points for discrimination claims and recruitment happens at the advertisement stage, at the application stage, at the interview stage, and in the hiring decision. So these are ones that I encourage everybody to treat very carefully. It's the first thing that you really should be aware of if you're trying to hire an employee, is that you have to make sure that you recruit and onboard them appropriately. This seems silly maybe if you're a micro business and you're just hiring your first employee, but to have these processes in place from the very beginning, even if it's going to be a small organization, is going to be really important for employee happiness, for retention, and being able to reduce the costs that you put into a new employee if they happen to leave. So advertisements. Couple things to know about advertisements. These are a point where if someone uses the wrong language in an advertisement for a job position, then it can lead to a discrimination claim. The key in advertisements is focusing on the requirements for the job, the skills or the characteristics or the abilities that are needed to complete the job's work, and not necessarily on the characteristics. So examples, rather than saying, I want to hire strapping young men, you can say, I need somebody who can lift 50 pounds, right? Or rather than saying, I only need young people who are tech savvy, you can say must be proficient in whatever the software is. Focusing on what is required for the job, not what are the characteristics of the person you want to have in the job, is the way to sort of get around those claims. It can be really tricky still. So it's best to advertise, focus on what are the job duties, what are going to be the expectations, if there's any lifting requirements, if there's any physical requirements, focus on those too. Just be careful. It's a potential risk point. On the application itself, there's a couple of things that cannot be done on the application if there is an application for a job. One of those is the ban the box. Ban the box is a law that prevents businesses from or employers from asking about a person's criminal history in an application for a job. So businesses can't ask about criminal history in any way, shape, or form on the application. We'll talk about the interview where they can ask about background and criminal history, but that's one that cannot be in an application. Also cannot ask for previous salary history in an application. There's a law preventing that because there's a lot of discrimination happening and folks moving between locations. There's big disparities between the locations and the salary. So can no longer ask previous salary history on an application. That information can be solicited in an interview. We'll go over that in the next slide, but it can be asked for. It just has to be asked for in an interview.
Nicole, is that a Vermont thing or is that a federal? It's Vermont.
No, that is a Vermont state law.
Okay.
Both of those, ban the box and no salary history.
Okay.
So how does one ask about that information? How does one get to that information in an interview? You got to ask sideways questions. So is there anything in your background that you'd like to share? We're going to pull a background check. Is there anything you'd like to share before we do that? It's a great way to open up the conversation to say, hey, employee, tell me what I'm going to find. You don't have to ask about criminal history. You can open them up to tell you their story, and that can often have a better result. A sideways salary question is going to be like it says here, what's your acceptable salary range? Tell me what salary you're looking for. What's the range? And then instead of saying what's your salary history, the person offers a salary range and the employer can determine whether the salary they can pay is within that range, and they can negotiate from there. That's how you get around those two bans though, is to ask during the interview. Don't ask on the application. Another thing to be aware of is that one cannot pull credit history for an employment application or for the process of hiring an employee unless one has written permission from the employee. So can't be a part of the background check, can look at criminal history, can look at traffic tickets, things like that, but cannot look at credit history as part of a background check if one is conducted. Other questions to really not ask about in an interview or on an application or anywhere else in the hiring process are these 6 categories, and others if you can think of them. These are protected categories where folks have been discriminated against in the past. So They have not gotten a job based on marital status, if they're married or not. People have not gotten a job based on their family status, how many children they have. Do not ask any questions about family, about children, about how many children, about marital status in an interview. Certainly don't ask for it in a job application. If that person is not hired, they may be able to claim discrimination on the basis of marital status or family status. Definitely cannot ask any questions about religion. Absolutely not. Medical history or disability, no. Age, no. Graduation dates, no. All those things have to be off the table in an interview. The reason
I
again
just
is,
have a question.
yeah.
So is there like an application template or something we can use for employee to fill out for the hiring
Right.
process?
There's lots of them available online. Nothing comes to mind personally. I don't have one that I recommend, but it would be just a quick Google search for employment application. There's going to be a lot of them available online though, Elam.
And also, like, how do we get their background check? Is there like a system or something we have to buy or pay for to get their background check done?
There is, yeah, there will be services that will let you, you can pay to do, usually it's like 30 to 50 bucks to do a background check for one person.
Oh, question on that. Sorry,
Yeah.
Nicole. Is that
Yeah.
something that you can just Google is like background check company? Yep. Oh, okay.
Yeah.
And those are there scammers who do that kind of thing too? Like background check?
There are. If you're seeing something that's like a Google ad, even though I hate sending people to Google ads, that's you know that it's been vetted. It's a company that's paid to advertise for that service. So you can usually, there's a higher degree of trust with those advertised services. They are ads. There are scams. I can say, I think that the one that I've used before is called Accurant. I wouldn't worry too much. You have to look through anything that you're seeing online that you're just doing a Google search for and try to vet it and make sure that it's a good service, that it's not a scam. There should be plenty that you can see with just a simple Google search though.
Okay. Great. Thank you.
Couple more suggestions here. Yes, and I should have written this on the slide. Maybe I'll go back and edit it later. Do not write on a resume or an application in an interview. If there's a potential employee claiming that there's discrimination based on a protected characteristic, they can use those documents and the writings on the documents in court to show that the employer was thinking about their age, was thinking about their family status, their marital status, all that stuff. So 3 kids on an application or a resume can indicate that that was a factor into making the hiring decision. So instead, it's okay to have a separate evaluation form, to not write on the resume or the application during the interview, but have a separate form that someone completes after an interview. The employer completes after the interview to say, this is what we noticed, this is what the characteristics that we saw that we liked. That may not necessarily come into litigation, but writing on a resume or an application is how people get, that's how they get discrimination claims. It's okay to keep separate notes too, but just don't write on the resume.
In terms of oh, sorry, go ahead.
Go ahead.
Oh, I was just wondering about the graduation dates, because like often, like as an employee, you're told add in your educational history. So, but like, it's just as an employer, we can't ask for that information.
You cannot ask it, right? It can be on the application, but you cannot ask for that in an interview.
Okay. And like
anything to try to gauge their age, just don't do it.
Oh, it's about age. It's not so much about education. It's just about age. Got it. Okay. Understood. Okay. Thank you.
Yep. Last item to put down here is that it's the description that goes out in a job hire advertisement and a hiring advertisement needs to match the offer, or the offer needs to be clear to the person who's taking the position. Because if they've pulled up an advertisement, they see the job description, they do the interview, and then the job description is different when they actually get the offer, that can cause confusion as well. Can cause lawsuits. Largely, many of the tips that we're giving you today are so you can not get sued. That's why we're doing this. Any questions on recruitment? There's one more slide on recruitment. A job description and offer be realistic, make it match. I am going to go over briefly the concepts of at will and then what needs to happen when somebody is onboarding. So Vermont is an at-will state. It's common to assume that that means that an employer may terminate an employee at any time. That's the common assumption. But the real explanation for it is that at-will means an employer may terminate an employee for any reason as long as it is not because they are part of a protected class. So an employer can terminate an employee when they want, except for on the basis of sex, gender orientation, age, national origin, race, religion, all of those things. That's technically the definition of at will. It is possible to have an at-will employment arrangement that's modified by writing. So anybody who has, especially just one employee, it can be really easy to mush those lines to figure out if it's an employee who's expected to be let go at any time for any reason, or if it's an employee who has some sort of job security or a certain term of employment in mind. Just make sure that it's clear. And if there is an employment agreement or an offer, be careful with the language in the offer or the employment agreement, just because it can turn something that is at will into something that creates an expectation of permanent employment or employment for a certain period of time. So, yes.
Sorry, can you explain that a little bit more? Because like with at will, you know, like the employers can let go at any time and like employee can leave, right?
I'll give you an example. In an employee handbook, someone says, we treat our employees like family, and we will only fire you if you steal from us, or if you commit arson, or if you whatever, right? They list out specific things that they will only fire someone for. You've now modified an at-will employment arrangement to be permanent unless that person does those things. Right? Or you take in an offer letter and it says, we are hiring you for 2 years. Here's the benefits, here's everything else, right? That turns an at-will employment arrangement into a 2-year contract. Does that make sense?
Yes, thank you.
Yeah. It's tricky and it's easy to do. And we'll talk about employee handbooks because those are very, very tricky. So when onboarding, when you've made a hire and you need to onboard someone, there's a couple things you really need to make sure that you have at that first point. One of them is 2 forms, the I-9 and the W-4. The I-9 is the employee eligibility verification form that has to be completed within 72 hours of starting the job. The employer has to keep a copy of the ID that the employee submitted with the form on file, and the employer has to actually physically see the ID and copy it to attach it to the form. We'll talk about employment handbooks, Ilham. I'm not sure. I don't have a resource on hand. I could certainly find one for you. We'll talk about them in a little bit, though.
Nicole, can the I-9 be done prior to the employee even onboarding, or does it have to happen at like the day, like within the 72
Technically,
hours?
72 hours of starting.
Okay, all right.
So if they start on Monday, it has to be completed by Thursday.
But could I
They could complete it beforehand. Yeah, they could complete it before they start.
Okay.
But I think, yeah, I'm not sure how that works. I'm sure that it can be completed before they start. Important to not try to influence any employees and what documents they put into their I-9. It's a weird thing, but there have been claims that an employer is discriminating because they're asking for particular proof of citizenship, for example, or of residence, or for particular pieces of ID that would establish some sort of fact about the employee's status. So the employee has to fill it out themselves. The employer does not say anything about what documents are required. The employee has to just do it themselves. Can't tell the employee what kind of ID to supply because the instructions are there. W-4 forms, those are tax. Those are just to set up the deductions that the employee is going to be taking. Those 2 forms, though, have to be completed on hire. Also suggest that if anybody is hiring, that at the point of onboarding, they set up the direct deposit forms if they have them, and that they get an emergency contact. If something happens to the employee, you want to have that emergency contact, and you want to have it from the very beginning of the employment arrangement. So get that information right at onboarding. If there is an employee handbook, this is a good time to have it signed as well. Some sort of acknowledgement that the employee has read or knows that there is an employee handbook, that it's there. They acknowledge that it's there and that they'll be bound by everything in it. We'll come back to the employee handbooks unless if you want to stop and talk about them, we can stop and talk about them now. We will come back to them though. Okay. Got a picture of my boys up here because they seemed like they were just unruly employees. Performance reviews. So managing people is a big part of having an employee. Obviously, you got to work with these people and you got to manage them day to day. There's a couple of things that can be done to sort of create a positive workplace culture and also to lay out documentation for an employer in the event that there is a claim against them in the future or in the event that there's an unemployment insurance claim specifically. So keep in mind, every employee is going to have to be managed differently. Nobody's the same, and it's going to have to be a one-on-one process and hopefully an interactive process with each employee. It doesn't necessarily need to be that the employee is just told what to do and when to do it and how to do it, but they also, in order for people to keep employees, they need to have some interest in helping the employee develop as well. What are their interests? Where do they want to grow? If there's multiple opportunities within the organization, it's good to have those conversations throughout the employment relationship. But performance reviews tend to be the real flashpoints, the points where employees and employers get together and they have that two-way conversation. Performance reviews are not mandated at all. They are recommended, but they're not mandated unless somebody puts into their employee handbook that they will conduct performance reviews at certain times. That, again, putting something into an employee handbook essentially creates a contract for the business to do what they've said they were going to do. So if the handbook says there will be a review at 90 days and 1 year, there better be a review at 90 days or 1 year, because that's a mandated performance review now. It's important to have the performance reviews. It's also important to have regular updates on those performance reviews. Annual is typical. It does create a better environment. The idea is that you don't want to have your employees come into the office only for bad feedback. You do want to have some sort of a structure to be able to provide them with positive feedback, constructive feedback. Performance reviews can often be a vehicle for that. If there is a need for performance improvement after a performance review, it's recommended, again, not mandated, but recommended that an employer put together just a piece of paper that's a performance improvement plan. The very simple summary of what was the challenges, what was the discussion, what did we agree the employee was going to be doing moving forward, what accommodations is the employer offering or providing the employee, when are we going to review this and see if there's been any progress. It's a basic agreement. It's a disciplinary contract, basically. But again, all of these pieces of documentation can really keep an employer covered in the event that there's some sort of a lawsuit or some sort of a claim that they want to prevent. I recommend that folks do not put an at-will statement into their employee handbook. I recommend that folks first don't modify the employment relationship in an offer letter or something like that, but that they don't, like a lot of people put into the employee handbook, we are an at-will employer, and that means we can do this. It's better to not define it, to not put it into the employee handbook and to keep that statement out, because the default is every employee is at will unless that's modified. Let's see, what else did I want to hit here? So follow the employee handbook. If you have one, you have to follow it. Do try to build a positive workplace culture. Performance improvement plans can help if there's discipline or training. And then again, document. This also feeds into unemployment. Again, the standard is if someone is let go for cause, they do not necessarily get to claim unemployment. If they are not let go for cause, for example, if an employer is downsizing or if they simply needed to eliminate a position, it's nothing to do with the person's performance, they just needed to eliminate that position, that is a no cause termination. That should trigger unemployment insurance benefits. Every time an employer has an employee, a former employee, make a successful claim on unemployment, the employer has to pay for those. Their insurance rates go up. That's why a lot of these things, that's why we recommend a lot of these steps be taken. Document everything, make sure that there's appropriate documentation for each performance review, make sure that the employee handbook is being followed. All of these things are to ensure that there is no litigation from former employees and or to make sure that unemployment insurance costs don't go up. I'm going to pause there because the next one is discrimination and retaliation, which we've sort of gone over already. Any questions?
So for the unemployment benefit, you're saying that the employer have to pay the employee, or does the state pay them?
The state pays them, and the state gathers the money to pay them through the unemployment insurance that you pay for as an employer. You have to buy a policy that will pay the state for unemployment claims from your former employees. Kind of a weird system if you think about it. Okay. Any other questions? Okay. This is discrimination and retaliation, but I'm focusing a lot in this slide on termination. That's a big, big pain point. Has to be treated very carefully. I don't think anybody in this room is a state employee, or a state employer rather, but state employers have to take an even more careful approach. They have to provide opportunity to be heard and notice that somebody's about to be fired from a state job. There is, though, similar concern that a termination even in the private sector will be handled or poorly, or that there's discrimination in firing someone. So here's some tips for what to do for firing an employee to try to prevent claims. Have a witness in the room who can speak to what was said, what happened, what the conversation was. Don't say I'm sorry. That implies some sort of fault. It implies that there's that there's something that went wrong, that maybe the employer made a mistake. Even if the employer made a mistake, it doesn't necessarily need to happen in that termination conversation. I would just say keep I'm sorry out of it. Do stick to the facts. A firing conversation should not be an opportunity to dump on the person that is being fired. It should not be a roasting session. Turning a termination conversation into a roasting session is one really good way to get a lawsuit against the employer. So keep it to the facts. We did this performance review where we identified this issue. This was the performance and improvement plan that we put into place. You were supposed to do this by this. You were supposed to do this training. You didn't do the training. You're still doing the stuff. We have tried again. We are no longer able to, this is not working out. You need to go your own way. That establishes that it is a for-cause termination. It's not a no cause. A no cause would mean an unemployment claim. It's a for-cause termination. The person was given a performance review. They had an issue. They were supposed to improve. They didn't improve. Now they're being terminated for cause. That should hopefully prevent an unemployment claim from that person. Way.
2 questions. How do you have a witness if you are like a small business with one person, or like, one other?
Ask a friend. Ask a friend.
Ask a friend.
It doesn't have to be an employee.
Okay.
Just a witness
not
who can say what was said.
Okay. Isn't that kind of weird though? Like to have a random person sitting in the room?
Yeah. Totally weird. You can, if you're a one person operator, if you're an owner and an employee and you have to fire the employee, you probably have somebody that's associated with your business that you could bring in to be like, so here's so and so, you met them before, they're gonna sit here for this conversation. But yeah, it's really weird to bring in a random person to be like, here's my witness.
Mm-hmm.
We're gonna have a conversation now. I agree.
I had a second question and I feel like I've forgotten it. So I will come back to it.
Okay. That's good. Discrimination and retaliation claims. We're already talking about this. So another couple things on termination. It's important to also, if there was any electronic access or access to information at the employer's job site or for their cloud server or whatever it is, it's important to terminate that access immediately when an employee is fired or terminated. Also important if there's any personal data on an employee's device. This was a recommendation that came up in a previous webinar because somebody asked, what if you know that your employee's been using their personal device to conduct business and there's data for the business located on their personal device? And the answer there was, should probably have the employee sign an agreement when they onboard that specifically says they will not do that, or if they are going to do that, what they're going to do with the data, how they'll protect it, that they'll give up the data and the device to erase the data at the end of the employment. Just know that anytime a business has customer or client information, that is stored electronically, it is being accessed from outside of the business, that potentially creates a data privacy breach concern. So that's why it's important to make sure that any employees who are accessing information for the business have that access removed immediately, and that they don't retain the data for customers. It's very common for employees to try to take a customer list or something like that out with them, though. Let's see. What are protected classes? So again, this is protected classes is what the court system has settled on for the description of groups of people who have historically been discriminated against or who have been treated poorly. So you can, on the basis of a characteristic. So here again, it's a characteristic that we call it, that's immutable, cannot be changed, that a person is born with, their gender, their sexual orientation, their national origin, their race, race, gender, disability, age, religion, sexuality, all of those things are immutable characteristics. And if someone is discriminated against on the basis of one of those immutable characteristics, then there is a potential discrimination claim. So again, at all these different points in being an employer, hiring, firing, promotion, even so far as putting an advertisement out to hire somebody, those things are all potential points where there could be a discrimination claim. Sounds kind of risky. But it's not as scary as it seems. It seems like there's a discrimination claim lurking out there for everybody, but maybe that's just the lawyer in me. So protected classes, immutable characteristics, things that people cannot change about themselves. These are things to be careful of, but also to make sure that if you have an employee who has a disability, who has some sort of a diverse characteristic, that you are aware of that you're making sure that they do not feel that they're being singled out. And make sure that they don't feel like they're being treated poorly or discriminated against on the basis of that characteristic too. So an employee who has a claim, who thinks that they have a discrimination claim, they file under what's called Title VII. It's federal law. There's a couple things that I've highlighted here for very common discrimination claims that employers should be aware of before they hire. One of them is the ADA, which is the Americans with Disabilities Act. That is specifically an act that only covers organizations with 15 plus employees. So probably doesn't apply to anybody here, but just to be aware, if one does have 15 plus employees, the ADA applies. What does that mean for an employer? It means that an employee who comes in who has a disability, whether or not it's documented, an employee doesn't have to document their disability to be able to get accommodations. The employee can ask for accommodations, reasonable accommodations, for any physical or mental impairment that's either obvious or that they assert they have. And the employer has to go through a process to determine what is reasonable, what's the burden going to be on them, on their business, how much is it going to cost, and they have to negotiate with the employee to find something that they can provide the employee to accommodate their need or their disability. It seems a lot more challenging than it actually is. This is the conversation with an employee who says, hey, I got a bad back and I need a lumbar support. And the employer says, sure, I can do that. That's reasonable. I can accommodate that need. Versus the employee who says, I need a totally new electronic standing desk and I need special footwear and I need this, this, and that. An employer can certainly look at all of those requests and say, I don't have that much money. It's going to be a hardship for us to provide all of those things. We can provide you with lumbar support and maybe one other thing to help you with your issue. So it's a negotiation. The point for employers is that it's not just a no, I will not provide that, or yes, I'll provide everything that the employee wants. There is a middle ground and some sort of arrangement for the employee to have a little bit of what they need, but the employer to not spend too much money. So that's the ADA and disability accommodations. Also watch out for the ADEA, which is the Age Discrimination in Employment Act. One cannot discriminate against a person who is 40 years or older. This is a federal law. This comes up a lot when it has to do with tech requirements for particular positions. The idea is that the 40 plus aren't as tech savvy, although I take that personally. I'm very tech savvy. Thank you very much. But if getting rid of an employee who is over 40 to hire a younger, if you're getting rid of an employee who is over 40 to hire a younger person, that could potentially be age discrimination. Or choosing between a younger person and an older person could potentially be age discrimination. Also, if one hires somebody who was over 40 and that person is struggling to use the appropriate software and tools that is required for the job, the ADEA requires that there is a similar interactive process with the person to say, okay, maybe you don't understand how to use Excel in the depth that we need. We'll train you on how to do it. Usually ADEA claims have to do with training, things that they can provide someone so that they can become familiar with the tools that are necessary for the job. It also applies in the inverse. It's possible to discriminate against people who are younger than 40. So be careful. Do not advertise, only want mature individuals with 15 years experience, right? It's better to advertise, want somebody who has 10 years of experience with this program or who is able to learn this program or something like that. Want to mention employment posters. I don't think I've actually done this yet. So employment posters are something that every employer has to have if they have one employee. And the employment posters are available at the Department of Labor. They will give you everything you need. You can download them. You can get physical copies from the Department of Labor. You have to have those, though, in a location where employees can access them. So for somebody who runs entirely online or who has a virtual office, who doesn't have a physical location, that could be a shared drive that employees can access.
Oh, question.
Yeah, go ahead.
So you mentioned that with the ADA, it sounds like it only applies to organizations or companies that have more than 15 employees.
For like accommodations for an employee.
Yeah.
Yes, an employer has to have 15 plus employees for that to kick in for the employees.
So when there are fewer than 15 employees, like a business doesn't have to make any accommodations?
It can make accommodations. It can make accommodations. It does not face a federal claim if it does not.
Ah. And is there any kind of like state like law?
Not that I'm aware of, actually. Let me just look at my notes and make sure that I'm not speaking too quickly. It's a federal law, age discrimination in employment.
Okay.
It's
just interesting because I mean, there are very few companies in Vermont that have 15 or more employees.
There are.
Yeah.
Different set of rules when it comes to making one's premises accessible for the disabled.
Right.
As opposed to providing reasonable accommodations for employees.
Interesting.
But yeah, there's no state equivalent. They go with federal.
Huh. Okay. Thank you.
Yeah. Any other questions on that before we move on, guys? Okay. Employee status. This is a real important point. There's a lot of risk here for somebody who doesn't appropriately qualify or put the right status on their employee. So I hope that everybody can pay attention here because this is probably one of the more important points. You can worry about discrimination and all that stuff, but if you don't pay your employees appropriately and you don't pay them overtime when they're supposed to get it, it's a big fine from the state. So first thing, there's two different statuses to properly qualify employees with. First time is based on the time that they're working or their arrangement with the employer. Full-time, part-time, seasonal, or independent contractor. You can see the statute there where it's defined if you want to look it up. Full-time FTE, full-time employee equivalent in Vermont is 40 plus hours a week. Part-time is less than 30 hours a week. Seasonal is 20 weeks or fewer each calendar year. Those three status marks are really, really important. If it's a full-time employee, their overtime kicks in if they work over 40 hours. If it's part-time, they may have certain benefits that kick in. Seasonal may be barred from some benefits because they're only seasonal worker 20 weeks a year. So it's important to know what each employee is qualified as. For folks who are working with outside contractors or vendors, or who are wondering if their employee is an independent contractor themselves, Vermont adopted the ABC test. This asks, this is a point of risk for an employer because it is very easy to look at someone doing a job for a business and say, oh, they're just an independent contractor. I don't have a lot of control over them. I don't want to pay them a bunch of benefits. I don't want to have all this stuff kick in. We'll just treat them as an independent contractor. They're a contractor. I don't have to do all this stuff. Very risky because if there are enough indicators that that person is actually an employee, then all those benefits kick in. If they have not, thank you, Wei Wei. If the benefits have not been provided to the employee, then the employee gets to claim those benefits. So, ABC test. The degree of control and direction that the employer has over the employee. Does the employer control where the employee, well, let's just call them a contractor. Does the employer control where the contractor goes, when they do the work that they do? Do they direct how the work is done? Do they have control over how all aspects of the job are done? That's one. Is the work that is being contracted for outside the usual course of this business? If this is a library and they're contracting with someone to come in and do carpentry, it's probably going to be an independent contractor. If this is a library and they're contracting with someone to come in and organize their books, maybe it's not an independent contractor. Maybe this is something it's within the usual course of business for this particular kind of organization, right? That's the second part. Customarily engaged in an independent trade. Contractors are typically those who you would think would be contracting individually with people. So think handyman trades, any sort of construction or woodworking, any sort of carpentry, electrician work, any sort of repair work or work that requires specialized tools. Those are typically independent trades. If an employer is contracting with a vendor who's providing those services, it's likely going to be as an independent contractor. Without these indicators, though, that says there's an employee there, not an independent contractor. Go ahead, Wei Wei.
2 questions. One, so full-time is 40 hours plus and part-time is less than 30 hours. Then what is in between 30 and 40 hours?
Technically full-time is like 30 plus, but it's 40 hours a week kicks in the benefits for overtime.
Oh, so like people who aren't at 40 hours, then they don't need benefits?
They do get, so people who are work between 30 and 40 hours a week are considered full-time employees, but they do not receive overtime because they haven't gone over 40.
Oh,
Technically, FTE is defined as 40 plus hours a week, but part-time doesn't kick in until 30. So anybody from 30 to 40 hours they're in between. They're full-time technically. They just don't get the full benefits.
I see. Okay. And then, so this is something that I recently came across with my financial accountant, the difference between a contractor and a consultant. Can you go over that?
Mm-hmm. I mean, a consultant is a contractor. The consultant is somebody who is contracting with a business to provide advice, basically.
Mm-hmm.
And so even there, like you might have an attorney who is an independent contractor, they're providing advice to the business unless they are hired to be in-house counsel, in which case they become an employee. A consultant is a contractor who what they're providing the business is simply information, advice, guidance, to do the things that they want to do. It's just a contractor who's providing a service, basically.
Okay, so it's the same thing.
Yeah, it's in terms of this slide, I should say that when we're trying to figure out whether somebody's an employee or an independent contractor, maybe there's a difference between independent contractors and consultants on the outside, but when it comes to classifying employees, independent contractor can be a consultant or somebody else.
Okay, thanks.
Monica, you had a question?
Yeah, is the ABC test a new thing? Because I know I work for the state and I know they employ a bunch of contractors or they work with a bunch of contractors, but it seems like those are slowly going away.
Interesting. No, the ABC test has been around for a while. It's used within the Department of Labor to figure out if someone is an employee and if they are an employee, whether they're entitled to wages and benefits. So it's not necessarily like has to do with state level contracts. Anybody who's contracting with the state is going to be an independent contractor and not a state employee.
Okay, I was curious.
They treat it very carefully. Yeah, it's a good question. Okay. Let's talk about, let's see, Miranda says, if your only employee is seasonal, do you still pay into unemployment insurance? I'm gonna have to look at the requirements for unemployment insurance because I think there's a trigger there. Yeah, if somebody has 1+ employee for some part of the day, if they're a for-profit business, then they have to have unemployment insurance, whether they're seasonal or not. Okay. Exempt versus non-exempt. This is the other category that folks have to get right for classifying employees. The first one is the full-time, part-time, seasonal, independent contractor. Second one is, are they an exempt or non-exempt employee. Exempt employees are salaried employees. Non-exempt employees are everybody else. So it's safe to assume that an employee will be defaulted to be a non-exempt employee. There has to be really a separate process, not a separate process necessarily, but there has to be careful consideration when setting up a salaried employee to make sure that all the hallmarks there for an exempt employee are there, because otherwise that person can claim the benefits that come along with being a non-exempt employee. Why do we care whether they're exempt or non-exempt? Non-exempt employees get overtime. Exempt employees do not. So again, assume that an employee is a non-exempt employee. If there is a salaried position, that typically they've got independent discretion and authority to make decisions for the business. They have hiring and firing authority for the business or for their department. Those are the hallmarks that indicate that there's sort of a salaried position, possibly an exempt employee there. And again, if it's anybody else, so everybody is defaulting to non-exempt and they should be entitled to overtime pay.
Question on that, Nicole. Under the exempt, all those like various qualities, is it like salaried and or independent discretion and judgment and or is it all three of those?
It's not all three of those. It's not a delimited list. It is an and or. These are indicators that someone might be an exempt employee. They got an annual salary. They have independent discretion and authority within their department or judgment to do what they need. They can hire and fire within their department.
Thank you.
Yeah. Let's see. I'm just looking at my notes here to see if there's anything else to fill in too. Really, the key for an exempt employee is, does the employee have discretion and independent judgment while they're managing other employees? It's really reserved for sort of management positions. Okay. Yeah, and it's big fines for somebody with the Equal Employment Opportunity Commission if you don't classify an employee the right way. We'll touch on sole proprietorships and what happens when one is just working by themselves or when one has like a partner or just one employee. We'll talk about that at the end because that's a big question that often comes up with little tiny businesses. Any questions on employee status before I continue on to benefits?
Yeah, I just have a question. So I do like a home takeout / catering, and sometimes my daughter, they help me. And so what is the age limit if I want to like hire them / or the legal way to have them work with
Yes.
me?
I've actually got a little note on a slide here. Under 14, generally prohibited unless it's an agricultural operation or farm. Between 14 and 17, they have restricted time and hours. They can only work a certain number of hours. I can pull up those notes if you want them, but that is the general restriction, is that before 14, unless they're working on a farm, they typically should not be employed in their family's workplace. That said, it happens all the time. That's where I grew up, in my mom's bakery. So it's just not technically legally allowed to hire a minor outside of that farm situation until they're 14. Okay. Moving on to employee benefits.
If
go ahead.
if they were 14 and above, I can do like a hiring, like a legally hire process, or just like have them help me when needed, or
Right. No, someone can be hired as an employee when they're 14 or older.
okay.
Yeah.
You know,
But that does mean that they have benefits that might kick in. Go ahead.
so do you know, because it said that it's restricted in terms of hours and maybe even what they can do you know what that might be?
Yeah. You want to go back to that?
Yeah.
Yes. So under 14, generally prohibited from performing any non-agricultural work. There's separate work for ag work, and separate requirements for ag work on the farms, and separate exemptions for younger than 14 if it's a business and working on the farm. So it's kind of treated differently. Between 14 and 17, they don't need a work permit necessarily, but they may not be employed before 7 a.m. or after 7 p.m. That changes a little bit during the summer between June 1st and Labor Day. They cannot be employed during school hours. They cannot do more than 3 hours a day on school days, and on non-school days, they cannot be employed more than 8 hours a day. That comes out to about 18 hours a week during school weeks. In the summer, they may not be employed for more than 40 hours a week. There's a child labor law poster that the Department of Labor has too that spells some of this stuff out. Does that help, Elam?
Yes.
Okay, good. Okay, benefits. Health insurance. Anybody who has more than 4 full-time employees has to provide, and the full-time employees are 30 plus hours. It's weird because it's defined differently here. Anytime somebody has more than 4 full-time employees, they must provide health insurance to their employees, or if they do not provide health insurance, they have to pay into the healthcare fund, healthcare contribution fund. Healthcare fund contribution. I'm sorry, I'm getting that wrong. That goes through, believe it or not, the Department of Taxes. The Department of Taxes collects, along with payroll taxes, the money that employers put in when they have 4 full-time employees, but they don't provide health insurance. So it's anybody who has 4 full-time employees or more is going to have some reporting requirements for health insurance coverage, if they're providing it or not. Something to note here is that if an employer does not provide health insurance to their employees, even if the employee has health insurance through somewhere else, when the employer reports, they have to say that that employee is an uncovered employee because the employer themselves does not cover them under their policy. COBRA kicks in with people who have 20 plus full-time employees. That's not going to be most businesses in Vermont, but anybody with 20 plus full-time employees and they provide health insurance, there's a process that employer has to go through when an employee is terminated to be able to make sure that the employee can elect for temporary coverage under COBRA. The employer pays for that. The employee pays a little bit out of pocket too. That has to be done within 14 days of termination though. Yeah, go ahead.
So if, you have a business that has 4 plus FTE, you have to do it. If somebody opts out of health insurance, what needs to happen then?
If someone opts out of health insurance coverage,
Mm-hmm.
the employer still has to report. They have to, I don't know whether they then have to pay into the healthcare fund contribution. Healthcare fund contribution. I don't know if they have to pay in for the employee who opted out.
Yeah.
I can find out if you want, but I know that if they do not provide the insurance, they have to pay into the fund.
So then it's more about going back to what you said before about documenting that they opted out of that so that we can show evidence. Okay.
Yep.
But I would like to know about, whether the contribution has to be paid into.
That's a really good question. Hold on. I will send an email to myself asking that question.
Great. Thank you. And
oh, sorry.
Go ahead.
Oh, I was going to say, let me just say that I will send out that information that Nicole finds after the fact.
Okay. So I just want to ask, what is the payment in lieu? What does that mean?
Payment in lieu?
Yeah.
Payment in lieu of, there's a lot of different situations that could apply to. It's a payment in lieu of doing something else. So in lieu means instead of. So payment in lieu of foreclosure, for example, would be somebody paying for the balance of a mortgage instead of going through foreclosure. That seems like it has a very specific question. Can I help any further with that?
No, it's just like due to like an insurance, like the job I do, like the health insurance. Even if you don't take it, they will pay you something. There was something payment in lieu. I don't remember the correct word, but something in lieu in there. But I just want to know what it is. Either they pay you if you don't take their insurance, or I don't know. It's confusing, but I just wanted to know what it is.
Yeah, it sounds like you've got the right idea in mind. It's payment instead of something else.
Okay.
So that was health insurance. Sorry, I'm just reading my notes here to make sure. So there's another one, paid sick leave. This is really important to make sure folks get right. All employees working 18 plus hours a week get paid sick leave. This is a state law. 5 paid sick days or 40 hours, they have to be allowed to accrue yearly. And in Vermont, an employer has to have a process in place for paid sick leave that's on the table at the end of the year. So if an employee has sick leave from the year that's left over, they have not used, the employer has to have a process to either allow the employee to roll it over into the next year to continue to accrue sick leave, or they have to have a process to cash out the previous year's sick leave. They have to have that process though in Vermont. Whoops. Okay.
Is that regardless of how many employees you actually have?
It's regardless of how many employees. Any employee working 18 plus hours a week is entitled to 5 paid sick days a year or 40 hours.
Okay.
And they have to have the process in place there. So the Family and Medical Leave Act is similar, but it's not, it doesn't require paid leave. It just says that, and for a certain size employer, so again, here, this doesn't apply to most folks in Vermont, but anybody who has 50 plus full-time employees, they have to provide 12 weeks of unpaid leave for birth or adoption of a child, sick family member that needs to be cared for, et cetera. That's the federal law. Not going to apply to a lot of people in Vermont, but the state law applies to anybody with 15 plus full-time employees. And the state law requires similar accommodation for anybody who has a sick family member they need to care for, or birth or adoption of a child. So if somebody qualifies for FMLA or the Vermont equivalent, that means that person has to be allowed to take 12 weeks of unpaid leave, and that they will have their position at the end of those 12 weeks of unpaid leave. There again, it's a potential pain point for an employer because there's discrimination claims that could be made all over the place for someone going on leave, somebody else being hired for their position, and then they don't have the position when they come back from leave.
Question on that.
Yeah.
Do you have to apply for disability in order to receive that?
No.
So that's just guaranteed.
Yeah, and I mean, an employee needs to document that they have a sick family member that they need to care for and that they are requesting the time off, and the employer should document that they're granting FMLA leave and holding the position. But no, it doesn't have to be a documented disability. Okay.
With that, I think you have to be like a full-time, right? Or you have to work a certain hours in order to get that.
It is full-time. That's correct. That's a good point. Okay. Other employee benefits, workers' compensation. So this is it's a expensive point for businesses because you have to get private insurance coverage. The state figures out what the rates are. You have to pay the private insurer, and you have to follow the policies and procedures that the private insurance company makes for workers' compensation claims. The idea behind workers' compensation is that we want workers to be protected against injuries. And so any injury related to a job duty or job performance or an extension of one's job, such as working from home, any injury has to be reported within 72 hours of discovering it. So it's basically it's two requirements. It's one has to provide workers' compensation insurance to be able to provide this coverage for employees, and injuries must be reported immediately. Want to emphasize that this really can be something simple, like somebody fell and twisted their ankle, or somebody has repetitive motion injuries from typing all day at their computer, or it doesn't have to be a major disability or injury. It can be something simple that an employee is like, this hurts, or this is bothering me, has to be reported within 72 hours. And then just wanted to touch on if folks are working remotely. I know that's a common question these days. It's more common these days, but it's not really been decided whether or not that creates, whether like if there's an at-home injury, the position right now is that anybody who has an at-home injury as an employee should probably make a claim, a workers' comp claim, if they get injured, because their home is technically an extension of the job. But there's not a lot of court cases looking at, like, if somebody trips while they're doing their own laundry at home, for example, is that going to create a workers' comp claim? Probably not. Haven't tested it much. Unemployment insurance, again, this is one that business has to pay to provide. It applies to any business that has one or more employee at some point during the day, which is pretty much all businesses that have an employee. So this is going to apply if a person has an employee. but it only applies to employees that have worked with the business for at least 20 weeks or who have been paid at least $1,500. 501c3s have a slightly different trigger there. They have to have at least 4 employees before they have to comply with unemployment insurance. So regular employers, 1+ employee, nonprofit employers, more than full-time employees. There are some special rules that apply to agriculture here. If there's different triggers, so somebody has to make more than $20,000 with the farm or with an agricultural employer, or the farm has to employ more than 10 employees or immigrants before their own obligations to provide unemployment insurance kick in. So I don't think that applies to most of the people here. Basically, provide it. Have to get the coverage. Provide it. Make sure that one is documenting. Here again, we're coming back to document. Make sure that any disciplinary actions, reasons for hiring, applications, performance reviews, performance improvement plans, any of that stuff is retained. The employee deciding to opt out of health insurance coverage, all of that stuff goes into a file for that employee, is retained for that employee throughout the employment relationship. If it's a long-term employee, sometimes you can throw that stuff away after like 10 years, but I would just keep it all. It's really, really important to have really good documentation as an employer. I'm going to pause there and see if there's any questions on those two before we move on to the last set of benefits.
Is unemployment insurance through a private insurance company, or is that through something?
I think unemployment insurance is actually through the state. Hold on
Okay.
a second. I should know that. Wow.
So if it's through the state, then does it automatically kick in? Because then the state should know that you have 4+ FTE or 1+ FTE.
Yeah, theoretically, yeah, but
Okay.
no, it's still going to have to. There's going to be a process. So yeah, it's a state administered program. So it's
Okay.
not a private insurer.
Okay. So state, and then so even if you have like as a business, you start to have one employee, like you should do your due diligence and make sure that.
Follow up with the state and get signed up for unemployment insurance. Yep.
And that's through DOL?
Department of Labor, I believe. Yeah.
Okay, great.
Yep. Yep. I'll put it in the chat. I'll gather some resources for this too. Okay. Overtime Fair Labor Standards Act. We've already sort of touched on this, but just to repeat, it applies to pretty much all employers. There are some qualifications for FLSA, but it's basically anybody who does any interstate commerce, which means if you use the internet at all, you're doing interstate commerce. So it basically applies to all employers. I would not try to do the analysis that says, do I fit under the Fair Labor Standards Act? Assume that the business does, and that it's subject to the FLSA, and that all non-exempt employees get paid overtime, time and a half after 40 hours. That's the basic requirement. But the other part of the requirement is that they have to get paid the federal minimum wage or the state minimum wage. So state minimum wage is $13.67 for non-tipped and $6.84 for tipped employees. That's basically FLSA. If anybody works with interns or volunteers, sometimes that's tricky as long as there's no expectation that there's a job on the other side of an internship or a volunteer position. That means that that's not necessarily an employee that needs to get paid. But if there's any question as to whether somebody who is helping an organization or a business out expects a job out of it or expects payment or continued employment, that might actually create an obligation to pay them under the FLSA. Another requirement for that is that obviously one must be able to prove timesheets and if overtime was paid, what the overtime hours were. So most employers do that anyways, just keep track of time. Last one, it's not really a benefit necessarily, but this is something that employees do benefit from, is safety in the workplace. All businesses have to comply with OSHA. All businesses in Vermont have to comply with VOSHA, which is the Vermont equivalent of OSHA, the Occupational and Safety Health Administration, or Occupational Safety and Health Act, actually. There's big consequences for failure to comply. you might think that it really only applies to folks who are doing industrial work or manufacturing or things like that, but it can be as simple as repetitive workplace injuries, carpal tunnel, things that have to do with office work, like any sort of potential injury. There needs to be some sort of awareness of it, and there needs to be potentially a process to guard against injuries. So the idea is workplace must be free from serious hazards. Serious hazard is not carpal tunnel, right? But any sort of repetitive injury or any sort of exposure to injury for employees could become a serious hazard. There are specific industry standards that must be followed. I don't think anybody here runs into any of those industries. There are some with the food and restaurant industry. Those are usually state-based regulations for for the safety requirements they must follow when they're running a kitchen out of their home or when they're running a professional kitchen in a rented space or whatever. So there are going to be some Vermont specific requirements for restaurants. It's important to know that not only do we have to provide a safe place for employees, but there are certain rights that come along with OSHA, which is that if the employer does not make repair of a serious hazard after an employee has notified the employer of the serious hazard, the employee has the right to make a claim to OSHA, and the business can't then fire the employee because they've essentially become a whistleblower. So treat concerns from employees seriously is the message here. Don't take it lightly, take it seriously. If someone thinks that there's a hazard, then that needs to be examined, documented, the process followed that is written out, and what was, this is the complaint, this is what we looked at, this is what we decided to do to deal with it, or we didn't think this was a serious hazard if that was the conclusion. And it can include external conditions as well. Think about frozen pools, falling ice, things like that around the place of employment. If you have an actual brick and mortar or physical location, think about those risks too. And then the state equivalent is VOSHA, covers private sector workers and state-run health and safety programs, must be as effective as the federal, can be more protective. All right. Last slide are the miscellaneous questions. I want to pause though and see if there's any questions about the benefits. Cool. So working with minors and volunteers, we've already talked about that, unless you guys want to go over it again. Somebody asked about copyright issues for employees. That was one of the questions that someone dropped with the registration. There's a couple of them that you should be aware of. One of them is that, well, let me back up for a second. Copyright is a right that that sits with somebody who has created something. So the standard is something that is fixed in a tangible medium of expression. And that's just a fancy phrase for saying that you can touch it, it's been created, it's been drawn, it's been recorded, it's been put into somewhere that you can touch, hear, see, or feel. Fixed in a tangible medium of expression. Creative work that has been fixed in a tangible medium of expression may be protected by copyright. Copyright simply means that nobody gets to copy that recording without permission of the person who holds the copyright. So if somebody holds a valuable copyright, they can potentially get money from somebody who wants to use their copyright, for example. That's called licensing. Or one can request permission from somebody else to use their own creative work. That's another form of license. So in employment relationships, it's important to be aware of the fact that anything that an employee creates for the employer, technically the copyright sits with the employer, called a work for hire. So think about my team. I have a lot of people who put together PowerPoints. They might put their own personal photos or hopefully stock photos that are not copyright protected from the internet into the presentations. They're doing a lot of work. They're doing the content. They're putting the notes together, all of that stuff. This is valuable material. Some of it's factual. You can't copyright facts. Like you can't copyright a recipe. It's just a bunch of facts put together in a list. But everything that goes into creating something that's a PowerPoint or a recipe or something like that, the story, the organization, the words, the illustrations, the things like that, that is potentially copyrightable. When an employee is doing that work for an employer, those rights are just going to go to the employer by default. It's a work for hire. It's within the employment arrangement. It's in the scope of one's duties. That the copyrights to the copyright to that work goes to the employer. It's possible to modify that, just like the default is an at-will employment arrangement. It's possible to modify the default work for hire arrangement. If you want to, for some reason, give your employees copyright for what they've created, you can do that. But that becomes a document that says that the employee gets the copyright. And I would suggest that any employer who has an employee that's producing materials for them, if they're going to give the employee the copyright, that the employer also put into that same document, but I want a license to use all of that stuff whenever I want to. It's easy to put that into the same agreement. Do think about copyright issues if one is in the business of making creative materials. Do think about it's anything having to do with drawing, writing, drafting, website content can count sometimes as creative work. Just make sure that if you have that sort of stuff in your business, that you're making sure that the copyright and the intellectual property rights are figured out there. Should I have an employee handbook? This is tricky. The folks that we've spoken to and the lawyers who are advising small businesses generally say that if you have less than 3 employees, it's probably not worth having an employee handbook. There's risk to it. I will say that there are some industries, like the childcare industry, has to have an employee handbook. They're required to have an employee handbook that says certain things by the childcare facility regulations. Outside of that context, though, no one has to have an employee handbook. Is it a good idea to do so? Potentially, as long as one does not make promises that will not be fulfilled in the employee handbook. The example again was if somebody says, we're a family and we won't fire you unless you commit arson or you steal from us. That means that person is hired and they will be an employee unless they commit arson or steal from the business. That can go into an employee handbook, and it's supposed to create a nice culture of inclusivity and people feeling comfortable and like they can speak their mind and all that stuff, but it creates a contract for the employer. So even something like we will conduct a review at 90 days in a year, have to do that. It's a contract when it goes into the employee handbook. Just be careful. Definitely, if somebody is going to have one, definitely have an attorney look at one. My service, which I'll go to in the next slide, we can find an attorney for you and we can pay for them to provide 10 hours of lawyer service for you if you want legal service. Employee handbooks, they're sort of tricky, but yeah. Okay, the last one was sole proprietors or people with 1 or 2 employees, because this is almost everybody in Vermont. Do solos have to give themselves benefits? No, they don't. It seems obvious, but it's confusing, right? Because these things kick in regardless of how many employees you have. So solo people who are sole proprietors don't have to give themselves benefits. People who are co-owners, if they have a fellow officer or if they have a fellow member in their organization, they don't have to give each other benefits either. But when there is more than 1 member or more than 1 owner of a business, there is a form that Department of Labor needs to be filed that says that these people are electing to not have benefits. If one has 1 employee, there are some things that kick in, like unemployment insurance. If anybody has 1+ employee during the day at some point in the day, there are some benefits that won't kick in, like the ADA stuff. And I didn't even complete the sentence there. Sorry. Some benefits apply, but not ADA if it's a small organization. If it was 15, if it's 4+ employees is where healthcare insurance kicks in, right? Anybody who only has 1 employee, they don't have to provide health insurance necessarily. The big things to know are that sole proprietors and co-owned businesses typically do not have a concern for providing employee benefits, but that they might have to file something with the Department of Labor to say that they're not taking employee benefits if they're a co-owner, but that anytime anybody has 1 employee, there's going to be posters that have to be put up in the workplace or made accessible. There will need to be benefits provided. There will need to be payroll handled carefully and all that stuff. So there's a lot of things that kick in. Basically talk to a lawyer or watch this webinar again to try to figure out what you need to know about before you hire your first employee. It's not that scary though. It is doable. And believe it or not, most people just bring on employees and don't worry about any of this, unfortunately. Go ahead.
So let's take an example of what someone put into the chat. Jose put in the chat. So like, let's say there are 3 co-owners and then they have a 4th employee. So do all those benefits then kick in?
1 employee, that means that some of the benefits kick in. So no health insurance.
Mhm.
Unemployment insurance has to be provided. Workers' comp has to be provided. What was the other ones? Hold on. So no, so again, we're going to look at whether the employee got to make sure the status is right, exempt, non-exempt, are they full-time, part-time, et cetera, for those benefits. Health insurance don't have, if it's just 1 employee, if the other co-owners are not, if they're not employees, if they're co-owners, they're taking a draw, then health insurance doesn't kick in, COBRA doesn't kick in. If employees are working 18 hours plus a week, they have to be provided with paid sick leave and a mechanism for rolling it over or cashing it out at the end of the year. They don't, if they are 1 employee, they don't have to worry about Family and Medical Leave Act, workers' comp and unemployment apply. And depending on the status of the employee, Fair Labor Standards Act or overtime might apply. And then if there's any safety concerns. So it changes based on the size of the organization and the employees.
So as long as the folks who are involved are co-owners and they submit that form to the state, then you don't have to have any of these benefits apply.
Correct.
It's just
Correct.
when you start to actually hire somebody who is not identified as an owner of the.
Correct.
Okay.
All right. That's the end of the content. Are there any questions?
Nicole, do you want to put the slide back up so that they can see what you
Oh,
were
yeah.
And while she's doing that, if folks do have questions and want to put it into the chat, please feel free. After this, like I said, we're going to send out some information, a follow-up with this information, as well as the slides and the recording, as well as information about any upcoming legal webinars that we're doing with Nicole. And actually, I think, Nicole, on the first, I think October 4th, we're going to have like a legal clinic. So it's going to be a virtual drop-in clinic. So anyone can come in and have, do you want to talk about it, Nicole? What are the?
Yeah. So we're going to hold virtual office hours from 2 to 4 p.m. on Friday, October 4th. I'm not sure if you decided to try to sign folks up for that. I'm happy doing drop-in. And it's just going to be an open meeting that anybody can drop into. Maybe we can work out a sign up later. Any legal questions for a business? Keep in mind that we can't provide legal advice. We can only offer education and information. But if anybody has legal questions or something that they want to work through with one of our team members, drop into the office hours, and we'd be happy to talk to you. If we need to set up a separate meeting for a private conversation, we could do that too. No problem.
Yeah, so I'll send out information about that. And outside of that opportunity, Nicole and her team are available if you want to talk about that.
Yeah, so we do legal education is primarily what the Vermont Small Business Law Clinic does. The Vermont Small Business Law Center is the one that coordinates the referral system. So the Vermont Bar Association has a panel of attorneys that likes to work with small businesses. And we have a pot of grant money that we can use to pay for 10 hours of work that the attorney does for a small business. So we have a program where we can educate you if you want to do a one-on-one consult or a group event like this. We'd be happy to talk to any business owner and answer questions. And then after that, we can send you on to an attorney. We get you ready to work with them, and then we pay for them to do the services that you need, write the documents, set up the LLC, protect, file for copyright, all of that stuff. The only thing we can't pay for is for an attorney to represent someone in litigation. If there's a lawsuit or an active court proceeding, you can pay for an attorney to support someone who's in a litigation, but we cannot pay for them to represent the business in the court case. You can see here sblc.vermontlaw.edu, or you can email us. There's our address. We do offer expedited services if anybody has been impacted by the 2023 or 2024 floods. We'd be happy to get you to an attorney as quick as we can, and then we can do a quick phone call to answer questions. So that's it.
Yeah, and I highly encourage folks to share this information out with other folks, whether you know that they have a business or not, because it's such a incredible service that is a free service that we have in the state. And often when I'm doing technical assistance with any business, this is the first source of information that I turn them to, because there's so many, just like so many nuances to building a business. So highly recommend that if you are starting a business, Ilham, or Miranda, if you're supporting other business owners, and this is specific to businesses and nonprofits, that you direct them to Nicole. Unfortunately, it doesn't apply to individuals.
Although I can stretch it pretty well. Like if somebody is self-employed and they can claim that they just do something on the side, I can find a way to get them some legal services.
Yeah. Jinli, welcome
back.
back. If you have any questions for Nicole, I know you missed a little bit of it, but Nicole's open for questions. We were just going over some of the details. I do see in the chat, Nicole, that Miranda asked, do the businesses have to be in Vermont, or can the person have a business in New Hampshire and live in Vermont?
Yes, so I haven't really decided that yet. I'm actually might be finding some funding to be able to serve New Hampshire businesses too. It's an internal policy question. If you're living in Vermont and you do business in Vermont, even if you have a New Hampshire entity, we don't really care where you're registered, but if you're doing business here is what we care about. So we will help people who have a Delaware corporation, for example, but they're doing business in Vermont. So headquartered, doing business, operating here, we'd like to help you.
Oh, go ahead.
No, I just have a question. So I have an upcoming meeting with the law business.
That's right.
Vermont Law Graduate School. So what kind of questions should I be asking? Because I don't know what to ask when I meet with them.
Yeah, I mean, you can ask us anything really. So I don't know what you put into the form that you submitted to us, Ilham, but we can answer any legal question. So some of the questions that we typically get have to do with, should I have an LLC or a corporation? What does that look like? What does the taxes look like? What do I have to file? A lot of questions look at what kinds of contracts or agreements do I need to have? Commercial leases to rent a space are a common question that we look at. Hiring and firing and employment questions. We look at a lot of licensing and regulatory compliance questions. So what permits are needed to run a business? What permits are needed to do a particular kind of business, like a restaurant or a home kitchen, for example? Anything. So if you are running a catering business out of your home, the topics that I would typically cover are going to include entity questions, are going to include contract questions, possibly for catering events. It's going to include a discussion of liability and insurance for events. If somebody's catering and they're delivering food, do they want to have an insurance policy that protects against injuries that might happen there? I want them to think about, do they need a permit, a land use permit for the location where they're going to have their home kitchen or their business? So that do they need to talk to the town for a permit? All of those things. There's a lot of legal issues that come up in basically any business.
Okay, sounds good. Thank you.
Yeah. Jinli, you had a question too.
Yeah, I just had a question about, so I signed up for one, but I didn't know if there wasn't any openings for the next 2 months. So I was like, no, it's okay. So I was wondering if there's any cancellations.
Right. What we are doing is, I know, and so what we will do too is that we'll have, you can actually check back on that link and just when cancellations open up, you can just take a spot that's available. We don't typically reach back out and say, hey, there's a cancellation, because we have a very high volume we deal with.
Right.
That said, we do have, we're starting to coordinate sort of group sessions on common questions about entities and contracts and copyright and stuff like that. We're starting to coordinate those so that if at the point you come into our intake, you know that you've got one of these couple kinds of questions and you're okay discussing them in a group setting, we'll have frequent sessions where folks can drop in middle of the day, end of the day, or whatever, and we'll just have a 1-hour session with one of our team members that can answer questions like that. So might be able to get you in sooner. We are booked out pretty far. This service has become enormously popular. We exploded over the last year. So we can't keep up.
And I apologize because I'm contributing to that
Makes me
volume. I will say, Jin Lee, Nicole and I will be running a drop-in clinic on October 4th from 2 to 4. So I'll send that information out. We haven't actually created a registration for that yet, but I'll at least send that information out to everyone who's participated in any of these webinars so that folks know. And hopefully that will be a regular, we're trying to do that the first Friday of every single month. And October 4th is our first one. So maybe what Nicole and I have to figure out a little bit more on the logistics on that, but maybe it's like, I don't know, 15 minutes, half an hour. I'm not really sure what that's going to be, and probably pre-registered. So I need to get on that because it's coming right up. So yeah. But hopefully that helps, Jin Lee.
Yeah. Any other questions, guys? All right.
All right. So thank you all so much for coming. I'm going to stop the recording.